When an arrogant lawyer and a dismissive judge cross paths with Caroline Leavitt, they assume the case will be a straightforward win. But what unfolds next? A masterclass in legal strategy that leaves everyone in the courtroom stunned. The courtroom buzzed with anticipation, a blend of legal interns, journalists, and curious spectators filling the gallery. A murmur rippled through the crowd, a hushed excitement lingering beneath the towering ceiling of the courthouse. The air carried the scent of polished wood and old law books, an aroma rich with history, authority, and the weight of countless verdicts delivered within these walls. At the defense table, Caroline Leavitt methodically flipped through her notes, her hands steady, her face unreadable. She had argued cases before, but this moment felt different. Today, she stood against Judge Walter Grayson, a man infamous for his short temper, his condescending demeanor, and his thinly veiled disdain for young attorneys, especially women. And as if that wasn't enough, her opponent was none other than Richard Calloway, a veteran litigator who thrived on courtroom theatrics. The case itself? On the surface, it was nothing extraordinary. A simple contract dispute, an employee claiming wrongful termination against a mid-sized firm. But with Calloway in the mix, the trial had already become a spectacle. He was the kind of lawyer who smirked before objecting, who treated every statement like a performance for an invisible audience. Even in a bench trial, where there was no jury to sway, he played to the crowd. And today? He had an audience. Caroline knew the odds were stacked against her. She wasn't famous. She didn't have powerful connections. She wasn't the type of attorney who made headlines. But what she did have: preparation. And she knew that, in the end, skill and strategy would outweigh arrogance if she played her cards right. As the bailiff called the courtroom to order, Judge Grayson strode in, his robe billowing slightly as he took his seat. He adjusted his glasses, his gaze sweeping over the room before landing on Caroline, then Calloway. Finally, he returned his attention to the docket, his lips pressing into a thin line. "Counselor Leavitt," he said, the corner of his mouth twitching with the hint of a smirk. "Representing the defense today, I see." Caroline gave a polite nod. "Yes, Your Honor." The judge exhaled slowly, as if already dreading what was to come. "Well, let's hope this doesn't turn into a law school seminar." Laughter rippled through the gallery, soft but pointed. Calloway grinned, not bothering to hide his amusement. He had seen this before. A young, idealistic attorney stepping into the ring, unaware they were already outmatched. But Caroline? She didn't flinch. Instead, she straightened her posture and waited. Calloway rose first, delivering a smooth, well-rehearsed opening statement. His voice carried an air of authority, dripping with confidence. He spoke of fairness, ethics, and corporate responsibility, painting his client as a hard-working professional who had been cast aside by a greedy employer. It was a compelling narrative, the kind that could make even weak arguments seem persuasive. By the time he finished, he cast a glance at Caroline, his expression almost pitying, as if she were a student about to stammer through a poorly memorized speech. The judge turned to her. "Counselor, your response?" Caroline stood, smoothing out her blazer. Unlike Calloway, she didn't pause dramatically, didn't clear her throat, didn't shuffle her papers for effect. Instead, she simply spoke, calm, direct, unwavering. "Your Honor, opposing counsel has presented a compelling story. Unfortunately, it lacks support, both in fact and in law." The shift in the room was immediate. Calloway's smirk faltered, just slightly. Judge Grayson tilted his head, as if only now considering the possibility that she had something of substance to say. But she could still feel the doubt hanging in the air. They saw her as young, inexperienced, an easy opponent. A brief silence stretched over the courtroom, a moment of stillness before the inevitable reaction. Judge Grayson tapped his gavel lightly against the bench, exhaling through his nose as if deciding whether to entertain her argument or dismiss it outright. "Ms. Leavitt," he said, folding his hands in front of him. "That was quite the opening remark. I assume you have something more than just confidence to back it up." A ripple of amusement spread through the room. A few legal interns exchanged smirks. Calloway chuckled under his breath, shaking his head as if this was all a waste of time. But Caroline? She didn't waver. She met the judge's gaze directly, her tone even measured. Your Honor, I would never assume confidence alone is enough to win a case. I rely on facts. Judge Grayson let out a short, dismissive laugh. Well, that's refreshing to hear. I'd hate for this to turn into a motivational speech. More laughter followed, this time louder. The courtroom fed off the judge's amusement. But Caroline remained unmoved. She reached for a document, lifting it with steady hands. If I may, Your Honor, she continued, let's discuss Colton versus Redbridge. A case that directly contradicts opposing counsel's claim that this termination was unlawful. Calloway let out a quiet scoff. That case doesn't apply here, he said, waving a hand dismissively. The circumstances are entirely different. Caroline turned to him for the first time that morning, her eyes sharp, unshaken. That's incorrect, she said, her voice steady. The precedent is directly relevant because the ruling in Colton versus Redbridge was based on a key factor, the presence of a contractual clause limiting termination discretion, which, in this case, also exists. Calloway blinked, momentarily thrown off. It was subtle, just a flicker of hesitation, but she caught it. And so did the judge. Judge Grayson remained still, his expression unreadable. But for the first time since the trial began, there was no amusement in his eyes. The game had just changed. And Caroline Leavitt? She was ready to play. Though Judge Grayson's fingers tapped idly against the bench, Caroline knew exactly what that meant. He was thinking, considering her point, even if he didn't want to admit it just yet. Ms. Leavitt, he said, reclining slightly in his chair, a knowing smirk tugging at the corner of his mouth. I appreciate the effort, truly. But do you really believe that a single precedent can override the fundamental principles of at-will employment? And there it was, the setup, the bait. He wanted to school her, to put her in her place with a simple legal lesson. The gallery sensed it too, a ripple of amusement spreading through the crowd. Even Calloway, seated smugly at his table, looked as though he was already drafting his rebuttal in his head. But Caroline? She didn't flinch. She didn't rush. Instead, she calmly flipped through her binder, pulled out another document, and held it up with unwavering confidence. Not a single precedent, Your Honor, she corrected, her voice steady and precise. 5. Each of them reinforcing the same fundamental principle: employment contracts with clearly defined limitations cannot be dismissed under the at-will doctrine. She paused, just long enough for the weight of her words to settle. Would you like me to list them? The air in the courtroom shifted. The quiet hum of whispered commentary stilled. The judge's fingers, once rhythmically tapping against the bench, stopped mid-motion. And Calloway? His smirk, so sure, so practiced, was now noticeably strained. Judge Grayson sighed, adjusting his glasses with a slow, deliberate motion. Well, Ms. Leavitt, he said, his voice dripping with sarcasm, since you seem so determined to turn this into a law lecture, by all means, educate us. The sarcasm was sharp, meant to undermine her, to make her feel small. But Caroline took it as an invitation. She opened her folder, already knowing that the next few moments would change everything. Without hesitation, she lifted the first document and began. Preston versus Briarwood Technologies, 2014. Her tone was steady, deliberate. The court ruled that despite an at-will clause, explicit contractual provisions on termination procedures take precedence. That case was presided over by Judge Holden, who, if you recall, Your Honor, cited your own opinion in a similar ruling the following year. That was the moment the room noticed. Judge Grayson's expression didn't change, not immediately, but Caroline caught the slight narrowing of his eyes, the flicker of recognition. She wasn't just quoting case law. She was quoting a case that directly referenced his own judicial philosophy. A few heads in the gallery turned, murmurs barely suppressed. The balance of power in the room was shifting, and Calloway could feel it too. Clearing his throat, he leaned forward, eager to regain control. That's still not comparable, he argued, waving a dismissive hand. That case involved a severance agreement that wasn't honored, which is entirely different from what we're dealing with here. Caroline didn't even look at him. Instead, she reached for the next file, flipping it open with the same quiet confidence. Wells versus Dartmouth Holdings, 2017. She let the name linger for just a second before continuing. No severance agreement. Just a termination clause requiring reasonable cause. The employer argued at-will discretion, but the court ruled that contractual obligations supersede the at-will doctrine. She turned the page. Another case. Burton versus Sven Corp., 2019. The name alone was enough to cause another shift in the room. In that ruling, the decision reinforced that at-will employment is not an absolute shield when clear contractual obligations exist. A hush settled over the room. No more chuckles from the interns. No more exchanged smirks from the attorneys in the back row. Even the casual onlookers, those who had wandered into the courtroom simply for entertainment, were leaning forward now. Judge Grayson leaned in slightly, resting his elbow on the bench. He wasn't laughing anymore. Calloway, shifting in his seat, glanced down at his notes. He had prepared for a standard argument, one where he could recite the usual legal rhetoric, get a few nods from the judge, and walk away victorious, without breaking a sweat. But Caroline wasn't playing along. The judge exhaled slowly, rubbing his chin as he studied her. "All right, Ms. Leavitt," he said at last, his tone more measured now. "That's an impressive list of citations. But let's be honest here, case law can be interpreted in multiple ways. Are you really suggesting that these rulings eliminate an employer's right to terminate under the at-will doctrine?" That was the test. This was no longer dismissal. No longer condescension. Now, he was engaging with her argument, probing for weaknesses instead of brushing it aside. Caroline met his gaze head-on. "No, Your Honor," she said firmly. "I'm not arguing that at-will employment is void. I'm arguing that at-will does not override contractual specificity. If a contract explicitly limits termination conditions, then at-will doctrine doesn't apply unless the language allows for it." She turned her attention,